Yesterday, I talked about the case that attorney Thomas DeVore brought forward in Effingham County, the accuracy firearms case, and how he consolidated his cases into that case, two in Effingham, one in White, and then you have the possibility that this could advance. So a judge ultimately telling the states that they are not going to grant a stay on the case moving forward as they move forward with getting discovery. Well, I chatted with DeVore yesterday to get a little bit more details on exactly what this means for the case, and also his reaction to the judge on the docket showing that he quashed two subpoenas that DeVore brought forward to subpoena records from the Illinois Sheriff's Association and the Illinois Association of Chiefs of Police. So those have been quashed, but he is, of course, going to be able to refile those. But it's not just those two organizations he's looking to get information on in the passage of the state's ban on certain semi-automatic weapons and magazines over certain capacities. He's also looking to get information from the Speaker's office, from the Senate President's office, from some of the advocates for this particular law that was enacted January 10th. So I talked with him, and here's some of what DeVore had to say, speaking about the hearing that they had this week.
Well, there was only two subpoenas that the court was talking about. It's one to the Illinois Sheriff's Association and the Illinois Association of Police Chiefs. And they were looking to complain. They don't want to give that information, which the judge is likely going to make them give. But as to those two subpoenas, there wasn't a date in a particular part of the subpoena that's supposed to have a date that my staff missed. It's not a big deal. It's procedurally nothing. So the judge just said reissue them and send them to him again. So, okay, we've reissued them and sent them to him again. So he didn't quash anything because he's saying that they don't have to give it. To the contrary, the judge was alluding very significantly that they're going to answer these questions. But that hearing's not till May 4th, where they're going to try to argue they shouldn't have to give the information. From what the judge was saying that I'll get to in a second, Greg, seemed inclined to, he's going to make them turn over discovery. But those two subpoenas, only those two subpoenas, because there wasn't a date in the top left corner. It's like, okay, big deal. But as to their request for stay, they argued to the judge that two things, really one, that why Dan Calkins' case is at the Supreme Court, that the judge should stay our case and not allow us to proceed with our case and our discovery request because they don't want to give us the information that they know is not going to help them. It's going to hurt them significantly. So they argued that since Dan Calkins' case is at the Supreme Court and since the cases are really identical, that the judge should wait and stay our case until the Supreme Court rules in Dan's case. And I argued that no, these cases are not identical. The Supreme Court didn't say they were identical because they didn't consolidate them together. That the governor's office and the attorney general and Dan Calkins asked for our case to be separate because it wasn't the same. And that really what they're trying to accomplish, I told the judge, is to just keep us from being able to get access to the discovery documents that we know is going to uncover really what's going on here. And so the judge said clearly, he says, these cases are not the same. He says the Calkins case is different primarily because they did no discovery. He said, I believe that discovery, is what distinguishes these cases. And so I'm not going to say it. And so again, you could read from what the judge was saying is that he thinks discovery is important. And so on May 4th, we're going to argue where they're trying to say they don't have to give any of this information, that they can hide it from the people of Illinois. And again, I never assume what a judge is going to do, but the judge seemed pretty clear when he's saying, I'm not staying this case because of discovery requests, that he's not then going to disallow that discovery because it would be contradictory to the logic he employed when he denied their stay. So that's pretty much what happened. He denied their stay, says this case will proceed because it's not the Calkins case. And then again, we're going to argue on May 4th, them trying to say we shouldn't have to give discovery. We've already fixed the two subpoenas that didn't have a date. Again, he didn't just said, Tom, I'm going to quash them, fix the date, and resend it to him. And I said, okay, we already got that done. So not a big deal.
So again, Thomas DeVore sharing some detail about the hearing they had earlier this week where the state tried to have the case frozen, essentially, to stay it in place, not allow it to advance while the Illinois Supreme Court deals with the Macon County case from State Representative Dan Calkins. DeVore indicating that the judge seems to recognize that the two cases are not the same, that Calkins is arguing the issues of equal protections and also special legislation, and the Illinois Supreme Court took that up, and even the Illinois Supreme Court also not adhering to DeVore's request to consolidate Calkins's case with DeVore's cases. So the Effingham County judge seeming to indicate that they are separate. They're different cases, especially with DeVore going after this discovery that he's looking for to get the communications, not just from the legislators, but also from police groups. And I think another really crucial thing too is DeVore, he's pointing out the issues of the training arguments that the state has, saying that that's why they carved people out, is because police and retired police and wardens and jail officers, they have more training than the regular citizen, so they can access these semi-automatic weapons while the regular citizen can't legally. So those are some of the arguments, at least, that distinguish DeVore's cases from Calkins's case that's up in the Illinois Supreme Court. So a lot of back and forth. But also I asked DeVore about the question of what about the issue of the Macon County case, the judge saying that it's unconstitutional, state police saying on their websites that, hey, it's not statewide, it's only for the plaintiffs. However, I can't get the guidance from the Attorney General's office to state police. They say that essentially it's attorney-client privilege, even though they work on behalf of the taxpayers. This is what DeVore has to say about that back and forth.
The ISP website says it on there, Greg.
Yeah, but is that enough?
I think that's enough to tell people that ISP is going to investigate these transactions. That's all it ever takes, right? I mean, the guidance, the Attorney General is, again, he's not dumb. He's not going to go out there and clear that all up, because the chaos that Calkins has created with his erroneous legal analysis, it doesn't hurt the governor and the Attorney General. It causes problems for the people, and they're okay with that. So they're not going to clear that up. But I can tell you that, I mean, if you go ask a lawyer that's not Dan Calkins's lawyer or the State Rifle Association, and they'll tell you it doesn't even make any sense what they're saying. And as I told you before, Greg, the best evidence you have is if what they were saying is true, why did the Illinois Supreme Court issue a statewide injunction in the Safety Act? Why wasn't the ruling out of Kankakee County enough to put an end to that? It's the same fact pattern. So, I've had people call me, and I can't mention their names, who the Illinois State Police is still investigating them for potential sales for people that aren't within the 7,000 that's in our restraining order. So that's a nothing. And you know what? Here, I'll give you the best one. If Dan or people that are promoting Dan's idea, like the State Rifle Association, what's that guy's name? Whatever his name is, tell him.
Ed Sullivan.
Yeah, tell him to go buy a weapon. Tell him to go buy one. And make sure the world knows that he went and bought one, and see if the Illinois State Police doesn't come knocking on his door.
So again, that's Tom DeVore, conversation I had with him yesterday, just reviewing some of the latest in the back and forth of the litigation against Illinois' gun ban. We obviously have more to talk about, as I believe today is when plaintiffs in the federal case, right? So DeVore's cases are state level. The federal cases, plaintiffs have to file their responses to the state in the Southern District of Illinois. So a lot of moving pieces. We'll do what we can to make sense of it all as we continue to evaluate the litigation against the broad firearms ban that the state of Illinois enacted on January 10th. All right. It's Springfield's Morning News. I'm Greg Bishop on WM.